The legal protection issues involve several points. Number one, a directors and officers policy, which typically costs between 4,000 and 6,000 euro, has limits of about €1,000,000 for the policy as far as a payout in the case of any suit and settlement. Its coverage includes actions of the board as well as proposed actions of the board in case somebody sues over an issue which may or may not be a board issue. And typically there is a tail, which means if you stop the policy ends even though someone may sue a year later about an issue that happened while the policy was in force. So a tail means that you sometimes will buy an extra year of a policy on closing down a corporation, selling a company, doing all those things where there might be a shareholder suit sometime in the future. And the legal responsibility at that point of all of the members of the board are to be careful and to follow what we call the business judgment rule. Make sure that every issue is discussed thoroughly enough that when it comes time to legal defense, there is no question that the board did its duty and took time to understand all the things it had to know. There are exposures sometimes to individual board members, but that exposure is covered by the D&O policy. So be careful that the policy is in place. Otherwise, individual board members can be sued. How do you reduce that exposure? Well, in the United States, we call it a Rule 409A valuation. It means using a professional appraiser to value the company's common stock for stock options so that the price per share is appropriate for the price per share being granted in the form of stock options. If the price were too high, then people could sue at a later time for having been given a value that didn't exist. And if people bought stock at a price that was too high, same thing. Outside legal advice is obviously a way of reducing exposure, for sure. And then, for nonprofit corporations, there is, at least in the United States, a Form 990 that is very lengthy, filled out by the company or the corporation or the nonprofit to be sure that there's no conflict of interest, among other things. One thing I would always want is an indemnification agreement between the members of the board individually and the corporation. In an indemnification agreement, the board knows that the company will use all of its assets if necessary to protect the members of the board in the case of a lawsuit. That kind of an agreement is important, especially if the corporation has assets. If the corporation has none, it is perhaps a piece of paper with no value, but it is a reminder to everybody that the corporation and the individual board member are linked. Careful deliberations. Remember I talked a minute ago about the business judgment rule? Careful deliberations are absolutely an important part of the legal protection of the company and its board